A company's approach to climate mitigation is not a marketing issue. It is now a hard legal issue. And how do we know this? Well, we've received a very clear signal earlier this year, in May of this year, from the Netherlands in the Shell case. And in these few minutes, I'm going to talk about the Shell case, where it has come from, what it means for private companies, and I'm going to do a bit of horizon scanning to have a look at its implications for banks, financial institutions, pension funds, and also for other companies. My name's Kinnari Bhatt. I'm an English qualified lawyer and I live in the Netherlands. I am currently a senior legal advisor for the Norinchukin Bank Europe, which is a Dutch subsidiary of a huge cooperative bank headquartered in Japan. We focus on investments into the food, fisheries, and agriculture sector. Prior to that, I worked at leading law firms for around up to 10 years. And then I completed a PhD, which has been published into a book and is here. And I also have done quite a lot of consultancy work with the World Bank and other NGOs, looking at all aspects of sustainability and project financing and equitable benefit sharing and natural resource governance in developing countries. On May the 26th, 2021, The Hague District Court in the Netherlands ordered Shell to reduce its CO2 emissions by 45% by 2030 relative to its 2019 levels. So the decision of the Hague District Court is an interesting one because it follows in the wake of the landmark decision of the Agenda case. And in that case, the Dutch Supreme Court ruled that by failing to pursue a more ambitious greenhouse gas emissions reduction target, the Netherlands government, the state, was in breach of its obligations under the European Convention of Human Rights. So essentially in the Shell case, what you have is the Hague District Court applying the same principles to Dutch private companies and finding that they too owe a duty to mitigate the impacts of climate change. So the decision is provisionally enforceable, and Shell has stated that it intends to appeal that decision. However, what's interesting under Dutch law is that even though Shell has said that it will appeal the decision, it is enforceable. So that means that Shell actually has to now start taking directions and putting a plan together to start to comply with the judgment. So what does this mean for corporations more generally? Well, I think even before this decision, the number of climate-related cases against companies was increasing. And there has been a pivot towards using human rights-based claims for a range of companies. Some have been successful and some have been less successful. There's a few that stand out, which I'd like to briefly touch on. There was one involving RWE, a huge company, energy company in Germany. And in that one, we have a Peruvian farmer which is suing the RWE for environmental damage caused by RWE's carbon emissions. And this one has surprised lawyers because they thought it would be dismissed for lack of standing, but the case is actually progressing through the courts in Germany, and it sends a strong signal that large companies are potentially facing financial liability for greenhouse emissions. So what does this tell us when we do a bit of horizon scanning? Well, as I've said, the number of cases around climate have been targeted at states. And of those, only a few have been successful. For example, the agenda case. So what this could say is that litigation efforts will now be focusing more on banks and pension funds. So the Shell case has been targeting big fossil fuel companies, and I think we can look forward and see that next in line will be banks, big banks that finance these carbon majors, and pension funds as well, who invest other people's money into these carbon majors. And then slowly from that, I think we can see other companies, larger companies, non-carbon companies being involved as well in these cases. So there are a few interesting points to note in the Shell judgment, which are relevant to all private companies. So the first one is that the legal obligation relates to Shell's entire energy portfolio. The second one is that Shell has individual responsibility to reduce its carbon emissions. And that is really key, because one thing that Shell argued was that it is just responding to societal demands for oil and gas. So this is a kind of a drug dealer's defense, saying that, well, essentially, if we don't provide this service, then people need it. Society still needs cheap energy. This is what we have, and if not, they'll just go to another provider. That argument was rejected. Shell also argued that globally its carbon contribution is not significant enough, and that was also rejected. And the key legal message here was that we all have a part to play. So Shell is now forced to take action. So what does the Shell case mean for financial institutions? Well, here in the Netherlands, the DNB is the Dutch central bank. So it's equivalent to the UK's Bank of England. And in the Netherlands, after the financial crisis, 2008, 2009, the DNB really stepped in and took a far more aggressive and approach to financial supervision. And over the last 5-6 years, they've been looking heavily at financial and economic crime and other kind of integrity risks, money laundering. A number of banks in the Netherlands have been fined, including ABN AMRO. And that is all a reflection of the importance that the Dutch regulator places on banks as having a crucial role to play as guardians of society, as they can channel millions and billions of euros. So I think it is fair to say that all the relevant Dutch regulators, including the Dutch Central Bank, are going to ask what institutions, financial institutions, are doing to commit to this issue of transition to net zero. And I think the Shell case tells us that they're going to be asking for some really concrete things. So it's not a case of, have you got a policy which is very high level and doesn't say very little, because actually one of the things that Shell was pulled up on in the Shell case was that its policies were not granular enough and they weren't specific enough. So in that case, the court actually asked for said that they should be setting targets, saying what steps they're taking, what interim steps, how they're going to monitor and how they're going to report. And in financial institutions, assessment, identifying your risks, assessing your risks, and then taking your monitoring and reporting, these are all very, very familiar processes for banks. And we've been doing them since 2015 on all manner of other integrity risks, such as money laundering, financial economic crime, sanctions checks. So this is the process. We know what the process is. And we know that the Dutch Central Bank, and I think the same goes for the Bank of England, are very active on climate issues. Perhaps here in the Netherlands, they're a little bit less active on other human rights issues, or the S in ESG. I think that will change when the EU mandatory human rights due diligence law comes in, because that will catch companies and require them to conduct human rights-based due diligence. But we already know, at least here in the Netherlands, that for the DNB, they're already asking banks for climate-related risk questionnaires. So what does that mean for your systemic integrity risk analysis? Well, I think that needs to be far smarter and far more granular. And the SIRA, which is systemic integrity risk analysis, has been one of the key priorities in the cross-sector supervision performed by the DNB. And it applies to banks, it applies to pension funds, trust offices, insurers, and they cover a wide range of integrity risks. So I would say that as part of a bank's approach to climate mitigation is first to be prepared and first realize that climate litigation risk is an important part of your operational risk tree, and it carries legal risk in terms of litigation, potential litigation risk, and also reputational risk. So one thing you could do is to consider adding climate litigation as part of your risk appetite statement, which is all banks will be familiar with the risk appetite statement. And this is already a significant mitigation. I think then you need to drill down and you need to assess your position beforehand and plan. So that could involve taking an objective view of your existing and your pipeline portfolio. So if you provide finance to the meat industry or to the LNG industry or to the coal industry, you need to think about that, especially if those investments those companies are in countries where there is a mature and well-funded civil society movement. Another interesting point that came up in the Shell case, which would also be relevant for banks, is that the court took into consideration Shell's current but also its legacy statements. So its good intentions, its policies, they were all used by the court to define Shell's duty of care. Now, of course, the Netherlands is a civil law system, so there are some, discrepancies between, the UK system and systems in the Netherlands, Belgium, and Germany, which are all civil law jurisdictions. However, the UK also has a duty of care principle, and it has a judiciary that is, I think, quite keen to develop the duty of care principle. So even though we're talking about different legal systems, I think there is plenty of room for cross-fertilization of standards and of ways that judges could look to other jurisdictions to fill in the duty of care in different legal systems. So if I'm to sum up and give you one main takeaway point to take home with you and talk about with your boards, it is that issues around climate, the kind of projects that you're financing, and your approach to climate mitigation and your transition to net zero, this is no longer a marketing strategy which can be kind of ticked off through beautiful green policies and using lofty statements. What the Shell case is signalling is that the private sector are going to be asked exactly what it is they are doing. And they're going to be asked what metrics, what their targets are, what they are in a concrete and granular way, what they are doing. Those metrics will be monitored by regulators, and then they will be called to account So if there is a mismatch then between what you say you're doing and what you're not doing, that gap is a potential legal risk area. And what the Shell case tells us is that there are a number of legal ways in which NGOs can intervene to form a climate litigation against a company. So that could be through human rights claims, it could even be through misrepresentation, it could be through consumer laws. So there are quite a few avenues, and I think that's the one major point, is that it's now a legal risk and no longer just a marketing brochure point.